Welcome to We Chat Divorce, hosted by Karen Chellew, Legal Liaison, and Catherine Shanahan, CDFA. Each episode, we sit down with divorce professionals and industry experts to provide insights and frank discussions about real people, real situations, and real divorce to help you achieve your best life post-divorce. This episode of We Chat Divorce is brought to you by My Divorce Solution, offering divorce financial planning so clients can secure the divorce settlement they deserve. Visit mydivorcesolution.com to request access.
Hello, everyone, and welcome back to We Chat Divorce, where we break down the messy, emotional, and often confusing parts of divorce to help you make smart, informed decisions every step of the way. I'm Karen Chellew, Legal Liaison, co-founder of My Divorce Solution.
And I'm Catherine Shanahan, Divorce Financial Specialist, CDFA, and co-founder of My Divorce Solution. We're here to give you the clarity you need so you can take control of your divorce, especially when it comes to your money and your future.
So today on Divorce Explored, we're going to talk about mediation. We talk about it a lot, but there's a lot of variables when we talk about mediation. Divorce mediation, court-mandated mediation, and settlement conferences all are under the same umbrella. They're some of the most common process points in a divorce, and they're also some of the most misunderstood. People search for things like, what is divorce mediation? How does it work? What should I bring? How is mediation different from litigation? And what actually happens at a settlement conference? These are important questions, but here's the part so many people miss. Mediation is not magic. It's not a shortcut around financial clarity, and it's not the place to discover for the first time that you don't have the documents, you don't understand the numbers, or you don't know whether the proposed settlement actually works for your future. And it doesn't matter whether you choose mediation, your attorneys recommend it, or the courts ordered it. The risk is exactly the same. And in fact, when mediation or a settlement conference is court mandated, the risk can be even higher because you may not have even chosen to be there. You may not even know your options. You may not feel ready, but the calendar says mediation is scheduled and you feel like you have to show up. And here's something people don't always know is going on. Sometimes a conversation at mediation or a settlement conference shifts very quickly. You may hear that if the case doesn't settle, the next step is trial. You may be told that trial preparation requires a large retainer, sometimes $50,000 or more. You may even hear, well, if you decide to go to trial, your attorney may say, I can't represent you because I feel like this is a good deal for you. Every attorney-client relationship is different, and this is not legal advice here at MDS. But from a practical standpoint, that moment can feel terrifying if you're not prepared. That's why financial preparation before mediation, settlement conferences, or any major divorce hearing matters so much. So today we're going to walk you through what mediation and settlement conferences actually are, how they work, what to bring, and why financial clarity before you walk in the room can change the entire trajectory of your divorce. I spent years working in and around the legal process, and what I saw repeatedly was what people were being asked to make major legal and financial decisions before they truly understood their financial picture.
And I've been in thousands of negotiations, and I've worked with countless attorneys in these situations, and it can be quite frustrating, especially when you're not prepared financially or you don't even know what to expect, right? You know, you mentioned a lot of things, Karen, talking about mediation, settlement conferences, and court-ordered or voluntarily going to mediation. I think those are all words that make you feel encouraged that you don't have to go to trial. But like you said, it's not a magic wand that you're waving there. You still have to have the goal to understand your marital estate. You have to evaluate your settlement options and know what they mean to you before you walk into mediation. Otherwise, you walk in there and you're just in a fog the whole time. And you're being pushed towards some settlement options that you're not prepared to accept. And then you have that remorse the next day. because typically you're signing a mediated agreement at the end of your mediation.
For sure. And, we're fortunate enough to be seeing more and more attorneys recognize the value of having their clients complete the MDS portrait before mediation, settlement conference, or certain divorce hearing. Because when the financial foundation is organized and verified before the meeting begins, the conversation can shift from confusion to actual decision making. But let's just start with the basics. Divorce mediation is a process where spouses work with a neutral third party, the mediator, to try to resolve the issues in their divorce: property division, debt support, parenting schedules, retirement accounts, real estate, business interests, and future financial obligations. The mediator is not there to represent either spouse. I think a lot of people get this confused. The mediator's job is to help facilitate the discussion and guide the parties towards possible agreements.
Well, I want to jump in right there. That means that they're guiding you, and oftentimes you'll hear them say things like, well, a judge wouldn't order that, or I'm telling you, the other side is sitting there and they won't budge on that. So you really, again, that's going to point out why you have to be clear on what the data is and not the emotions.
For sure. And mediation can happen in a few different ways. Some couples choose it voluntarily because they want to stay out of the court system. They want a less adversarial process. In other cases, attorneys recommend it. And in many jurisdictions, the court actually requires it, either as a step before trial or as part of a scheduled settlement conference. A settlement conference is essentially a mediation in front of a hearing officer. Sometimes it's ordered by the court, sometimes the parties and their attorneys, and sometimes a judge or a judicial officer tries to resolve the case before it proceeds further. But however, in any of these settings, the same fundamental truth applies. The mediator, the judge, the conference officer, none of them can make the financial facts true. They can only work with the information that's brought into the room.
Okay, I'm going to stop you there again, because as you're talking, it reminds me of what a brother to a client said just this week. He said, well, wait a minute, won't the judge say this is not correct to the opposing party? Like, these numbers are not true. Look, they're uneven. Like, so I'm glad you said that. Can you explain just a little bit what the role of the judge is there?
Yeah, or the settlement conference officer or the mediator. And I often hear myself saying, look, they're not there to find conflict where there is none. They presume that everyone's verified the facts and the data and the documents before they get there. So the questions they will ask, is everybody in agreement? You'll hear the word stipulate. Is everyone stipulated to this? That means everyone agrees on this because the document doesn't seem to exist. So it's not the judge's job, again, or anyone's job to verify data and documents once it gets into the courtroom. It's their job to hear what either you or your attorneys are bringing to them for consideration, and then they apply it to the law. So not necessarily private mediator, because they're not judges or lawyers. I'm really talking about hearing officers. Mm-hmm. So, that is very misunderstood. And so, we've even had cases, Catherine, where we'll have a client come in and we'll talk even about, we were asked about spousal support. Well, why didn't the mediator bring it up? Well, it's not their job, you would hope they would, but their job is to get you to a settlement. And so it doesn't seem important to you. Again, they're not going to throw something in that's going to upend all of your settlement discussions.
Oh, yeah. I've heard mediators say, or a client will say, well, wait a minute, we never got those documents. And the mediator will say, well, either did I. Okay, well, now what, right? I mean, I don't want to talk bad against mediation for sure. I mean, anyone should go to mediation and try it before trial. Trial is so expensive, and you're leaving it in the hands of a judge, right? But you have to make sure that you have the documents. And if you don't, then you might have to go through the court system to get them, unless you're willing to totally compromise on verifying any data.
Yeah, for sure. And, mediators and conference officers and judge will ask for documentation to be provided, but there's not necessarily a verification process. That's That's with you and your attorney, or MDS does it as well. We do the whole verification process, but that's very unique to MDS
Oh,
outside
and
of
that,
the court system.
right. And they use those a spreadsheet. How many? Oh my gosh, how many spreadsheets do we get? I mean, we got one today that was $400,000 off because they forgot a couple of columns. Okay. Well, if you're in mediation, you're not bringing that up. You're just looking at these numbers as if they're fact.
Yeah, you mean as a mediator, right?
Yeah,
Yeah,
yeah.
yeah,
And even the client. If
yeah,
they look good, people can make spreadsheets look very pretty. But if you're not verifying that data, it's not so pretty post divorce.
yeah. And that is a reason that mediation often fails, because if the financial information is incomplete, disorganized, outdated is a big word there, or
Mm,
one-sided, the process is operating on a weak foundation. And people often assume that mediation or a settlement conference will create clarity. It'll create positioning, not
right.
necessarily clarity, but more often those meetings reveal where clarity is missing.
I totally agree with that. I just got a little sidetracked here because there's been so many cases this week with mediation, and
It's only Wednesday.
oh, it's only Wednesday, and I'm exhausted. But listen, I'm a trained mediator. I love mediation. I love negotiation, but it's very frustrating when people are not prepared. They're not prepared by their attorney or themselves, and they're relying on a third party to get this verified information, and it just won't happen. And there's so many people that are so disappointed after these mediation appointments because they didn't get what they wanted, or they didn't know the expectation of the mediation, right? So it's good to ask really good questions, even if you're self-representing, meaning you're going to a mediation that's just with a mediator and your spouse. Ask that mediator, what's the expectations of today's mediation? And do we have all the information? Did my spouse submit all the information? And where is it? Like, you need it. And if not, maybe you need to postpone that mediation.
Yeah, for sure. I had a client going to a court mediation actually today, settlement conference, court mandated settlement conference. And she's very concerned about, well, we're not ready to mediate because all my spouse's documents are not in. So what do I do? We're required to go. It's a court order. We have to go. And so we had the discussions about, well, these are things you can discuss. You can discuss spousal support. You have enough information. You can discuss what is the marital pie and what's missing. And so there are a couple of other issues. And I said, talk with your attorney about, can we discuss and cover this area, because it will get us to the next step. And will it satisfy the requirements of the mandated settlement conference? So her attorney said, well, I would like to try to settle this case, but I understand where you're coming from, and we'll stick within those parameters. So she's agreed to it. Hopefully they do. I haven't found out yet. But there are these discussions. They're very good, productive discussions you can have about hearing dates with your attorney ahead of them, so that you can know, to your point, Catherine, what the expectations are and what is the outcome that everyone is trying to accomplish.
Well, let me further dig into that, because you're bringing up a very good point, and it's exactly what we're talking about. You gave her these really great questions to ask because she shared with you how she was feeling. And then the attorney's response was, well, I really want to settle this case. So the attorney was going into that mediation with a settlement in mind. The client was going in like, I don't have all the information. And so now you have a level playing field between you and your own attorney to go to mediation. That in itself should make you feel better, by just knowing what the expectation is and that you're both on the same page.
Exactly. And it can be done.
Mm-hmm. Mm-hmm.
So when people search, how does mediation work? They want to understand what actually happens in the room. This is what we're talking about. Generally, the parties identify the issues that need to be resolved, basic data and information, the financial information exchanged or reviewed, right? You'll read that online, you hear about it, and the financial information exchanged or is exchanged or reviewed doesn't necessarily mean that is verified. And that's where MDS is always signaling a problem, a challenge, because just because information is exchanged or reviewed doesn't mean it's complete, accurate, or verified. And that's what we try to drive home every day. But here's the issue. People often focus on reaching an agreement before they understand the financial consequences of that agreement.
It's important to hear what Karen is saying. And the most important part of that, well, maybe not the most important, but what I find it's important because you're going to call us a week later and say, oh, I didn't really understand that's what they meant. I mean, I can't even tell you how many times people say that to us. You know, they go and think that they're understanding, but they don't, and they're afraid to say something. They're more focused on, we have an agreement here and we just want to get it signed because we're so over our spouse and we just have to be done with it. And I totally agree with that, and I totally empathize with that. But you can't come back later and say you didn't understand the financial consequence, because it's not going to change it.
That's right.
So although things, a lot of times they look fair, right? Or they look unfair, like a spreadsheet that was sent to me today. They were trying to point out how unfair it was to our client, actually. But like I said earlier, there were a couple of items missing that they forgot they were missing. The tax consequences weren't taken into place in the calculation. Separate property was overlooked. Like, there's so many things that you have to make sure are verified on these spreadsheets before you say they're either equal or unequal. Again, it goes, your emotions get mixed in there. You see a number that wasn't even properly added up, but your emotions are like, of course he's screwing me over, right? Instead of verifying the number and be data driven instead of emotional driven, and you'll come to a better resolution at the end. It just further goes on to the 50-50 division. So many people say, well, we have, you're getting 500,000, I'm getting 500,000, you're getting 5 million, I'm getting 5 million, whatever the number is. Are you comparing apples to apples? And maybe not, maybe you did make some compromises to settle, and that's okay, as long as you know what they were and you know what the impact of those are.
Right. So when you're going to mediation, the better question is not, can we agree? The better question is, do we understand what we're agreeing to? A productive meeting is not just about whether both people are willing to sit at the table and be amiable, right? It's about whether both people have enough reliable information to make informed decisions at that table. I can't tell you how many people call us for help 2 days before mediation and say, well, if mediation fails, I'll give you a call back. The prep time for that mediation, the attorney prep time is extraordinary, probably 3 times our fee, only to walk in with fingers crossed. You didn't call us for help if you were clear about going into that mediation.
Yeah,
so
that is the point there. If you're making a call 2 days before a mediation, your mediation needs to be rescheduled because you are not clear. And when you say they have to understand what they're agreeing to, it's so important, because when you get the actual written marital settlement agreement that you have to review, if they didn't interpret in word what you thought you understood, you're going to have a problem. So if you don't understand what you agreed to, you won't understand if your agreement was written properly or not.
Exactly. And that pressure of signing a mediated settlement agreement can feel very real. It's very common, and most of the time it happens that if you get to an end of a mediation and your attorney and the mediator feels that you all are close enough and should be signing a mediated agreement, and you may say, well, I'm not ready, or I want to think about it, you can expect to hear, well, let's prep for trial, and I need a retainer. And if you're not going to sign this, these are our next steps. And that's not always the case, because you can agree the day after. So it's about setting expectations ahead of time with your attorney, or even with your spouse or the mediator, if you're in private mediation, about what you hope the outcome is, or what your goal is for the outcome at each mediation session.
I'm glad you brought up pressure and fear, because fear is not a settlement strategy. Exhaustion is not a settlement strategy. I can't afford trial is not the same as this settlement makes financial sense.
Absolutely. So, Catherine, can you talk a little bit about today about a case that we're currently involved with, where the attorney wanted the client to settle because the client didn't settle? They started talking about very high dollar amounts of retainer, or we're going to excuse ourselves from the case 2 weeks before trial. Can you just talk a little bit about that experience? It's a very real experience that really happened.
Yeah. So I hope we're talking about the same person. There were so many this week, like I said earlier. But
Yeah.
yes, we do have ad hoc services that we can help a client negotiate. We're not lawyers, so we don't provide legal perspective. But in this case, the opposing attorney said yes, he would get on the case and talk to us about it, hoping to get them to a resolution. And it's amazing how we can communicate and get to the bottom of it. But this particular case, she really wanted one of the real estate entities. And she, all along, she never asked because she never thought her spouse would agree to it. But when we're making these asks based on the financial data and she no longer could afford the other one, and we go back, yeah, the other side, it changed their mind and she couldn't believe it, right? But I mean, I don't know what the point of this story is that you wanted me to get to, honestly.
Yeah. I wanted you to get to that because I want people to understand that there is pressure. It's very common to have pressure from your attorney at mediation. And then if you don't settle, then you pay 50 grand, 100 grand to go to trial, or the attorney has the option of withdrawing from the case.
Oh, yeah. And they leave you high and dry, which is really sad. And the
It
sad
can be
part,
done.
they're done.
Happened.
Yeah, it happened. And husband's attorney was using that also as pressure. Listen, we're up against a deadline. But it was funny because he kept putting deadlines and I need to hear from you by tomorrow, 10. Okay, well, I'm busy tomorrow at 10. But he was okay with that. I mean, I actually spoke to him. But they do put this pressure on you back and forth, right? It's like a tennis match. But you know, she is holding her ground. Sometimes we hold it a little too long also. So you have to be aware of that. If you're coming to the heels of a trial or something, you do have to make decisions. And what's happening is emotions still creep back in. They're long marriages, a lot of these cases. It's really hard just to put an end to it because you're definitely going to be scared at whatever the outcome is because you're always compromising somewhere in mediation. It is part of your divorce. But you have to be able to be, if she wasn't so informed, she couldn't even move on without an attorney. She is informed. Hopefully they get to an agreement this week. But attorneys can fire themselves.
Yeah. And this happened. She doesn't have time to get another one at this point. So before we close today, I want to just touch on why attorneys are using MDS before mediation, conference, and hearings. And this is one of the reasons more attorneys are recognizing the value of MDS. So let's just lay this out. Attorneys are trained to advocate, negotiate, draft, litigate, and protect legal interests. They often don't have the time or the infrastructure to take every document, organize the marital estate, verify the financial data, reconcile the missing information, model settlement scenarios, or walk client through the financial trade-offs to the extent that's necessary for you to understand the financial impact. So that's where MDS fits in. We're not replacing the attorney. We're not giving legal advice. We're providing you and your spouse with a professional team with a document verified financial picture so the attorney can advocate from a stronger foundation. So when you and your spouse walk into mediation or a settlement conference with the MDS financial portrait, you're not saying, I think this is what we have. You're saying, here's what's been identified, here's what's been verified, here's what we still need, and here are the financial implications of different settlement options. That changes the quality of the conversation.
Most importantly, it's going to help you understand what you're agreeing to before you agree. The portrait reduces confusion before mediation or even at a settlement conference. It actually helps attorneys focus on legal strategy instead of basic financial organization. So it supports really more effective mediation, negotiation, any conference or hearing preparation, and it gives everyone a clearer baseline. It's a symmetry of information for you to make really smart decisions for yourself.
So here's the takeaway. Before mediation, before a settlement conference, before any hearing where financial decisions are on the table, even support conferences, Make sure you understand what you own, what you owe, what is missing, what needs to be verified, and what each settlement option may actually mean for your future. Please, please do not walk in with unverified number. Don't rely on spreadsheets. As we just said, don't assume the disclosures are complete. And don't wait until the end of mediation to realize you don't understand about your financial transactions. Because if the case doesn't resolve that date, the next conversation may be something that you're not ready to face. That is not the moment you want to start getting organized.
Mediation, settlement conferences, and negotiations all work better when the financial foundation is visible, organized, and verified. And just remember, clarity, financial clarity, does not increase conflict. It often reduces it.
Absolutely. So thank you for joining us today for this episode of Divorce Explored. If this topic resonated with you, visit mydivorcesolution.com to learn more about the MDS Financial Portrait and how we help people prepare for mediation, settlement conferences, attorneys' meetings, and the financial decisions that shape their future.
Thanks for joining us on another episode of We Chat Divorce. We hope this episode was informative and supportive on your divorce journey. If you're looking for more support for navigating divorce with confidence and clarity, head over to mydivorcesolution.com for more podcast episodes, divorce events, and resources for your divorce. We'll see you back here for our next episode.